Welcome to the Is It Time for a Lawyer podcast with attorney George Lamb. Each brief episode will focus on a specific legal topic to help you better understand the situation you're in and what your next steps might be. Let's join George for this episode. And welcome back. Today we are in the studio with attorney George Lamb. And George does a lot of family law here in Jefferson County and the surrounding counties. So today we're going to jump into the topic of custody and parenting time. George, welcome back. How are you, guy?
I'm good. How are you?
Well, I'm doing good. So we talked about divorce planning in the previous episode. So as we kind of go through the whole process, obviously the situation where you have children involved, so custody and parenting time is going to be a real part of that overall process as it plays out. But there's a big misconception, and I'm going to ask you to clarify that for us.
Okay. Just at the outset, a lot of people, when you're talking about custody, a lot of people think that custody has to do with where the child is, and it doesn't. It's not how many nights your child spends with you versus the other parent. It's not physical custody like people tend to think. Custody is really about decision-making, and it's not small ball items. It's the big ticket items of decision-making. It's rooted in constitutional law. You have decisions that you have to make, overarching decisions, either medical decisions or educational decisions or religious decisions. And that's what you're talking about when you're talking about joint custody or custody for that matter. And there's two types of custody. There's joint custody, which is the default law in Kentucky, versus sole custody, which is an exception to the rule, so to speak. And so the first thing when you're talking about custody, and I would say that whether or not it's a divorce case or a custody case, and so whether or not you were married parents or you started out as unmarried parents and you were never married, the same rules apply. And so the first step is, who's going to be a custodian, and meaning, is it going to be joint decision-making or sole decision-making? Generally speaking, it's joint decision-making. Some exceptions to that rule would be, if somebody's unfit. And fitness of a parent has to do with, they could have mental health issues. They could have drug problems. You can end up in a situation where the parents can't agree on anything. There's just no agreement on any big ticket item, and the courts say, okay, we're going to have one. Rare, but that can happen. At some point, if two people don't agree on anything, then you just can't function, and then you would pick one. It's kind of rare because in Kentucky, the default position is joint custody, equal decision making, and equal shared parenting time or visitation. Go ahead.
And it really wasn't always that way, right? This is a relatively new development in the law over the last, 5-8 years maybe?
Yeah, it's relatively new as far as law on the books. Now, as society has evolved from one working parent, say 30 to 50 years ago, to two working parents, to traveling parents, now you have people working at home. But for the most part, the model was, if you have unmarried parents, the model was, you had the children living with one parent the majority of the time, and then, if you know people that are a little bit older, they were at the other parent maybe one night a week and every other weekend. And so now it's equal. It's designed to be equal unless there's a reason for it not to be. And sometimes that can be, it's not only due to behavior, sometimes it's due to practicality. And so, for instance, you could have parents that live too far away. You could have parents that live in two different states. You could have parents that live in the same state, but just, Paducah to Pikeville, as you might hear, or Louisville to Bowling Green, or whatever it is. But basically, we're in a system where you have equal decision-making and you have shared parenting time. And so that's what people would say, okay, 50-50. Well, then you have different ways to do a 50-50. And so it kind of depends upon what your situation is and what may work for your family. You could have, we can get back to that. You can have a different parenting schedule for different people, but what I would say is, and what the law says is, not me, is that best interests of the child are the factors that dictate how this works. Okay. And so there's basically a list of factors that courts consider when they're trying to make these determinations if there's an issue between the parents and people they just don't agree. And so one question that comes up aside from the factors is, and this comes up a lot, is people say, well, does it have to do with money? And so in child support factors in, and we'll talk about that in a later episode, but it's not a pay to play system. And so, when I think about it, when you think about it in terms of laws and state laws, the same laws that apply to Bill and Melinda Gates would apply to everyday Joe and Jane. And so you could be, quite frankly, the richest person in the world, but you might not be able to see your children for other reasons. Or you could not be the richest person in the world. You could be the exact opposite, but you could see your kids every day. It just kind of depends on your specific situation. But it's not, I pay child support or I don't pay child support, and I either get to see or not get to see my children. It just doesn't work that way.
Right. And again, it comes back to that premise, which the judge and the court is ultimately trying to determine what is in the best interest of the child or the children. And I think that's a big threshold. And sometimes when you're going through an emotional situation, you don't necessarily want to consider that. You may think your way is the right way, and there's a lot of messiness that comes into play. But that's where you're supposed to have that neutral party.
Yes. I mean, what happens is that, and you're absolutely right. Obviously, you're in a situation where you're not for whatever reason, you're not with your child's parents. So maybe you agree on all this stuff, but odds are you probably don't. And so the courts look at, it's called all relevant factors, but they look at a handful of factors and they look at them all to try to figure out what's in the best interest of the child when you're talking about determining custody and determining parenting time. It would be the wish, and just for example, some of them would be the wishes of the parents, okay? Either one parent or both parents. The wishes of the child, if appropriate. That's an age-appropriate thing, and it could be the capacity of that child, how is the child adjusted to where they live, where their home is or homes are? Where do they go to school? How are they rooted in their community? Mental and physical health come into play. That's considered.
And that would be the mental or physical health of the parent, right?
Sure. I mean, it's the mental or physical health of all individuals involved. So, I mean, you kind of have to look at human beings. They're all human beings. And so you kind of have to look at the interactions between those human beings. You could have a child that has needs, and that parent, you could have a child that has needs, and the child has mental health needs that need to be addressed, and those parents need to be able to address them. And so that's why it's all individuals involved. As far as, relationships, what is the relationship between the child and each parent? What is the relationship between the child and their siblings? Maybe how those siblings interact with those parents. Is there a history of domestic violence? Is there a history of substance abuse? What environment is the most stable? What environment is the most safe? As far as how that goes, and just by way of example, some of these things can interrelate, and so, or they're kind of part and parcel of each other. So, for instance, when you have a school-age child, and say you have parents that do not, in Jefferson County, we're a big place, okay? In some of the smaller jurisdictions, it might be a little more workable. But in Jefferson County, it's a big city, and once you're a school-age child, you can only go to one school. And so, the question is, where does this child go to school? How far is that from one place to the other? And so you go to school generally where you live, unless not, but that's kind of how it's done. And so the question is, how does that affect parenting time? Well, that can also feed into custody, because that's a custodial decision, because that has to do with education. So you can have a good faith, honest dispute as to where your child goes to school. You may not agree, not only because your school's closer or this school's further away. You just happen to might think that the school that you have in mind for your child or children is better than what the other parent thinks. And so that can affect, that's a custodial decision that can obviously affect parenting time. And it comes up quite a bit. And so when parents who probably try to agree as much as they can, when they don't agree, these factors come into play, and that's how it plays out. And so that's just one example of many. We touched on parenting time, and in a 50-50 schedule, you could be 1 week at one parent, 1 week at another. You can alternate within the week. You can have chunks of time where you're a couple days at this house, a couple days at the other residence, and then you kind of alternate weekends. But it's not necessarily cookie cutter, because it may not work for age reasons, logistical reasons. There are certain things where sometimes if you can agree to something that maybe a court wouldn't do, because your life, your child's life better than anyone. And so a lot of people will try to agree to a parenting schedule that works because, quite frankly, you got to live it. And it's pretty hard to raise kids, and it's pretty busy. And if you can have some choice and make an agreement on something as important as that, some people will take advantage of that if they can.
Well, I think that makes sense. And again, I would think the judge might actually listen to that agreement, because again, the judge is not there on a day-to-day basis. He or she is sitting here going, okay, I'm dealing with what's in front of me. But if both the parents are saying, hey, we agree on this, it's not typical, but it works for us, and it's also healthy for the kids, and here's why we believe that, I would think the court would be inclined to say, all right, yeah, let's put that in writing.
I would say the majority of the time that they do, the court has tools that they can use. They can appoint a friend of the court to kind of help them investigate and make those decisions. They have to make sure that an agreement is conscionable, that it's fundamentally fair. But I happen to think if it's reasonable and the parents have said that they want to do it, that the court will at least give them a chance to do it.
Yeah,
because they're the ones
that doesn't work, right?
Because they're the ones that have to live it.
Yeah,
and so do the children.
Well, as we close out, we talked about how the courts have kind of caught up with society in terms of now it's more that presumption of joint custody, 50-50, and things like that. But in society today, there's also the reality of de facto parents. Do you want to talk about that for just a few minutes?
It comes up, and so what happens is that you have adults that raise children that their parents, in fact, is what that means, where they are the caregiver, they're the financial support of the children, but they're not their biological parents, and they can have custodial rights. And so the law contemplates those folks as well.
So that could be a grandparent, that could be an aunt or an uncle. Maybe there's a special relationship there. Maybe the aunt or the uncle stepped in and has been playing a role in the child's upbringing. So, again, they kind of get a voice or a seat at the table, it sounds like.
Exactly. They're a person acting as a parent.
Interesting. And I guess we'll close out with this. Regardless of how the parenting time is established or how the custodial situation is ultimately resolved, there is a possibility of modifying that down the road, correct?
There is. I mean, nothing is, as they say, set in stone. So you can modify things based on a change in circumstances. Now, does that mean if you make an agreement today in 4 days that you can change it? I would say probably not. However, if there is a substantial and continuing change in circumstances, or something comes up over the course of time, and it kind of depends on when, because there's certain triggers in the law that require different things as far as how you might pose a motion in court. There's some time components to it, but you can go back to court and seek modification in the best interest of the child, depending upon your specific situation. Because, when you're talking about children, they're children until they're 18. And so if you think of a baby and then you think of a legal adult, that's 18 years. A lot can happen in 18 years. And so, yes, you can go back and make changes and request changes and move the court for changes based on factors regarding the best interests of children as those circumstances or needs arise.
Outstanding. George, if someone wants to pick up the phone and get in touch with you and say, "Hey, you know what? We're going through a divorce. I need to seek counsel. I'm thinking about going through a divorce," which was kind of the previous episode when we were talking about divorce planning. What is the best way for them to get a hold of you?
The best way to get a hold of me is my cell phone. That's 502-640-9797. You can call me. You can text me. You can also reach me at george@lamandlamb.com. That's george@lamb.com.
Fantastic. And then with the next episode 5 coming up, we're actually going to jump into the topic of child support. So we're kind of taking a phased approach to this, and we're going to talk about some other topics outside of family law. But right now, this is kind of the core practice. So we're doing that. So if you're listening to this episode, I hope you enjoyed it. I hope you found it insightful. Obviously, you may have questions, and that's why I would definitely encourage you to get a hold of George on his cell phone and just have a conversation and get some clarity from somebody who's been serving the Jefferson County area and surrounding counties for the last, 15 years or so, George. So, I mean, you know this area of law, so it's something you're dealing with every day, and you might be able to simplify it for some people.
Yes, sir. I appreciate it.
Absolutely. We'll be back in about 2 weeks. Take care.
Thank you.
Thank you for listening to the Is It Time for a Lawyer podcast with attorney George Lamb. We hope you found the discussion informative and helpful. The comments George made are not meant to be legal advice. Listening to this podcast does not establish an attorney-client relationship. However, if it is time for a lawyer, George is ready to listen. Be sure to share this episode on your social media. George will be back in 2 weeks with his next episode. Thanks again for listening.